This is quite remarkable. I am delighted on behalf of Hofstra Law School to welcome Professor Richard Painter, who has taken time from his busy schedule teaching at the University of Minnesota Law School and from his significant public speaking, his public appearances, to join us today to deliver the Lichtenstein lecture. Later today at 5 o'clock, he's going to be on CNN, so I encourage all of you to watch that. Right? Before I introduce Richard Painter, a few words about Howard Lichtenstein. The Howard Lichtenstein Distinguished Professorship was established in 1989 to remember Howard Lichtenstein, who was a labor lawyer who worked at the firm of Proskauer, Rose, Getz, and Mendelsohn for many years, and he was considered an authority on administrative law. He set up this professorship because he was a strong advocate for the teaching of legal ethics. And so, on behalf of the school, we thank him for the fact that we get to do this on a yearly basis. Each year, we select the person to deliver the lecture, and we focus upon the key issues raised that year, perhaps that month, that day. And in that regard, 2017 and 18, a paramount concern is the integrity of our government and the role that government lawyers play in assuring a robust democracy and enhancing and preserving that integrity and the trust between the citizenry and its government. Needless to say, these are unique and challenging times for such concepts. Justice Louis Brandeis famously said, "Our government teaches the whole people by its example. If the government becomes the lawbreaker, it breeds contempt for the law. It invites every man to become a law unto itself. It invites anarchy." Professor Painter is perhaps the lawyer in the country, the legal ethicist, to best offer trenchant commentary today about a lawyer's role in government. Many of you are currently enrolled in legal ethics courses and have yet to focus on the unique and significant contributions of government lawyers. Others of you are in con law or other courses. You've examined the critical constitutional and ethics issues facing government and government lawyers in particular. Professor Painter, as many of you know, has been outspoken about the challenges to the constitutionality, the ethics, and the norms of good government in recent times. He is one of the few law professors in the country who has become a public figure by numerous television appearances, editorials in the country's leading newspapers, social media posts, etc., etc. He's been described on Twitter, Facebook, and by TV commentators, and by many of you as brilliant with a dry wit, pulls no punches, not afraid to speak his mind no matter what. Those are among the comments that you can pull off social media. All of that is certainly true, and so much more. Let me tell you a little bit about his background. He's the S. Walter Richey Professor of Corporate Law at the University of Minnesota Law School. He graduated from Yale Law School. He clerked for Judge John Noonan of the Ninth Circuit, and he worked at several law firms, including Sullivan and Cromwell here in New York. From 2002 to 2005, he was a professor of law at the University of Illinois College of Law. That's when I first encountered his work, when he taught and he wrote extensively about corporate ethics and securities regulation. His perspective at that time was unique, as he was one of the few Republican law professors in the world of legal ethics. From 2002 to 2007, he was White House ethics lawyer in the administration of George W. Bush. He then returned to teaching at the University of Minnesota Law School, and his book, Getting the Government America Deserves: How Ethics Reform Can Make a Difference, was published by the Oxford University Press in 2009. Professor Painter is a board member and vice chair of the Citizens for Responsibility and Ethics in Washington, known as CREW, which filed suit that you'll hear about today and you probably know about, against President Trump for violating the Foreign Emoluments Clause of the United States Constitution. So, Professor Painter, we look forward to your comments. Thank you so much for being here.
Thank you very much, Alan. Thank you so much for not reading the social media commentary about me from Breitbart News, Fox, news. And Guns and Ammo has a blog site, I think, that seems to have been quite critical. I guess I've had some difficulties with the NRA since I published an op-ed in the New York Times in 2011, or at some point back there, after the Sandy Hook massacre, calling the NRA a protection racket and the Republican Party. They didn't appreciate that. And so, yeah, there's all sorts of interesting stuff that can be said about me on the blogosphere. Some of it true, some of it not. And the topic I want to talk about with you today is the role of lawyers in addressing conflicts of interest in our government. Conflicts of interest have been the center of my scholarly work and my teaching since the very beginning when I went into law teaching in 1993. And I had worked here in New York City. I was on the Association of the Bar, the City of New York, Ethics Committee. And we had looked at a bunch of conflict of interest issues. And I taught corporate securities law and looked at the serious problems that lawyers have to deal with when a lawyer is a lawyer for the corporation and they are talking to the CEO and the officers about a problem, but the problem's not getting solved and it's a serious issue. What do you have to do when there's a conflict of interest between the officers of the company and the directors of the company and the shareholders? Well, I always said you have to go up the ladder and actually talk to the directors and explain to them what's going on. Because after all, the organization is your client. We had a lot of fighting back and forth about that at the city bar in New York City, and then at the ABA, and then eventually Congress got the act and the Sarbanes-Oxley Act and said, well, look, if you're a lawyer for a corporation, you have an obligation, if you know a securities fraud, to go to your own client's board of directors and tell them about it if you can't get the problem fixed by the chief executive officer and the chief legal officer. And that's an example of a serious conflict of interest problem within the organizational structure of a publicly held company. I have taught examples involving privately held companies and various conflicts of interest there. That's where I spent most of my time until 2005 when I went into the Bush White House as a chief ethics lawyer. And I very quickly learned about government ethics regulations applicable to all United States government federal employees. And of course, some of them were also lawyers, so I would constantly have to remind them that they had certain obligations under the ethics rules for lawyers in the states where they happen to be licensed. But I learned very quickly that government is essentially about conflicts of interest as well. The role of government lawyers is very much involved with the work of trying to deal with the various conflicts of interest that arise for government officials. The big picture here is that government officials should be responsible to the public interest, should not be making decisions based on their own personal financial interests, should not be making decisions based on their own particular sectarian connections or religious affiliations. There's a separation there, a conflict of interest which the founders addressed in our Constitution. Government officials should not be making decisions based on undue influence from political parties and certainly political campaign contributors. And so we have those conflicts of interest between political operations that elect elected officials and the actual official role, not only of the elected officials, but those whom they appoint. And conflicts of interest between political interests, campaign funders, and the official role of the government and of government officials. And then, of course, the independence of the judiciary, the importance of the judiciary, that branch of government being independent of political concerns. And the role of the lawyer often involves advising government officials on where the appropriate boundaries are, and when a boundary is clearly being crossed, saying so and addressing the problem. What I'm going to do is discuss some of the most important conflict of interest provisions in the United States Constitution, provisions that I would refer to as being in part about conflicts of interest, and in the United States Code, and in the regulatory, the regulations of the Office of Government Ethics, and also the Hatch Act regulations that pertain to political activity by United States government officials, and discuss the very challenging situations that we have in recent years, but particularly in the Trump administration, in addressing these conflicts of interest, and what lawyers can do to hopefully keep government officials focused on their task of serving the public interest rather than allowing these conflicts of interest to unduly influence their official duties. Let's start with the Constitution. And I see parts of the First Amendment really being about conflicts of interest. Europe, for centuries, have dealt with conflicts of interest from the conflation of religious identity with politics. And ever since the Reformation, the bitter wars between Catholics and Protestants, and the attacks on the Jews, the expulsion of the Jews in Spain, and that religion and politics were too intertwined. The United States, the founders of the United States wanted to have a different vision of the role of government and the relation between government and religion. They wanted a separation. They did not want that conflict over here. People had come here for religious freedom. Now, the early years of the settlement of America, they didn't always observe religious freedom. The Puritans who escaped Great Britain for their own religious freedom weren't too tolerant. Really look at the history of the Salem witch trials. But by the time of the founding of the country, it was recognized that religion should be separated from the role of government in two ways. One, that there should be no establishment of a church, a particular religion. And then second, no interference with the free exercise thereof. And that's one of the reasons when people ask me when I first became quite angry at then candidate Trump, other than the fact that I know he didn't pay back a lot of people lent money to it and borrowed money from here in New York State. It's when he said that people should be banned from immigrating to our country or subjected to extra government surveillance because of their religion, targeting Muslims. And we just don't do that in the United States. The founders did not intend that and specifically prohibited the interference with the free exercise of religion. They did not want that conflict of interest over here. We're not going to have the expulsion of the Jews or the expulsion of the Muslims. We aren't doing that in the United States of America. And that's a conflict of interest that wreaked havoc in Europe, tore Germany apart in the 30 Years' War, had done so much damage, and we weren't going to have it here. And my message to President Trump, at the time I criticized him for that, is we're not doing that. That is not the American tradition, and it's right there in the First Amendment. The First Amendment also, of course, guarantees the freedom of the press, and that is another area where in many countries the ruling political party ceased to get control of the press quite quickly. And that was going on in Europe at the time of the founding of the United States, where the king would always seek to try to control the press, and they would use various statutes and sedition acts and so forth to go after the free press. And the founders of the United States recognized that the press was supposed to be separate from the government, separate from government control. So we not only have freedom of speech generally in the First Amendment, but freedom of the press. And of course, I have become quite frustrated with the recent attacks on the freedom of the press, because things can change very quickly. In Germany in the 1930s, when the NSDAP political leadership, of course Hitler at the top, we're talking about the Lügen press, the lying press, there was actually a quite robust free press up till 1933. When Hitler took control, apparently only 4% of the newspapers in the country were affiliated with the NSDAP, the Nazi party. Within about 6 months, it was up to 96%. So if you have a government that wants to get control of the press very quickly, and people allow that, it can happen quickly. And we see what the results can be. And that is something the founders anticipated as being a problem and did not want over here. And I feel very threatened when I hear government officials constantly railing against the press, even though, of course, there is going to be anger or criticism from the press. But that's what being a government official is all about. There's going to be these papers that like you, those that don't, and TV stations that like you, and those that don't. But the constant rhetoric targeted at the press in this administration, for me, is very disturbing. And then some concrete actions that I've been quite concerned about. When, for example, the president targets CNN repeatedly in tweets and in his verbal rhetoric, and then CNN's parent company, Time Warner, is going to have a merger with AT&T, and the Justice Department is going to go and challenge that merger in court. And I think what the Justice Department wants is that CNN needs to be sold. This is an antitrust suit. Now, Republican administrations occasionally, yes, do bring antitrust suits once in a while. This one is a stretch. That's why most of my friends who are antitrust lawyers tell me that even the most liberal Democratic administration probably wouldn't consider it's an aggressive move to say that in order to merge with AT&T, Time Warner has to sell CNN. Now, who wants to buy CNN? Rupert Murdoch. That's interesting. I thought he had another news outlet. Would that be an antitrust problem? I guess we'll deal with that later. So the problem is that when you have repeated attacks on the press, you could say there's no violation of the First Amendment merely because the president wants to criticize the press for fake news, every other day in a tweet, and usually 2 times in a tweet. Okay. That in of itself doesn't violate the First Amendment. He has a First Amendment right to say that. But when you have concrete action that might very well be motivated by that, antipathy toward the press, I've become concerned. When you had tweets threatening the NBC license, when you have the attacks on Amazon, why is he upset at Amazon? Well, Jeff Bezos of Amazon, founder of Amazon, also owns the Washington Post. I don't think it's Amazon he's worried about, it's the Washington Post. And yet he will then go after Bezos by saying, okay, what we've got to do is change the tax treatment of Amazon, which is actually a legitimate issue. But the problem is you have an all-powerful, very powerful central government in the United States, and enormous amounts of power there. When the president himself is not only attacking the free press, but suggesting and hinting at ways in which his government might go after the free press. I've become concerned, and I wonder about the role of the Justice Department lawyers. I have not seen the communications back and forth about that antitrust suit against Time Warner, about CNN. But if there are political motivations there, the communications from the White House, whether it's an email or over the phone or in meetings, is our Justice Department lawyer in the antitrust division is going to speak up and say, this is wrong. This is use of the antitrust laws to infringe on the freedom of the press. Are there other areas in which there is going to be an attempt to infringe on the freedom of the press? Because essentially that First Amendment is about that conflict of interest and the need for independence of the press so that the press is not controlled by the government. We are in danger with the amount of rhetoric that we have seen in recent times. Hostile rhetoric addressed, targeted at the press. And of course the Constitution has other conflict of interest provisions. I can skip through some of the amendments and talk about an obscure one, dealing with financial conflicts of interest. Well, it was obscure until about 1.5 years ago. Never taught in the constitutional law courses, certainly not in my course, when I took a course in law school some 30 years ago. The Emoluments Clause of the Constitution. What is that? Is that some obscure provision? There's really a technical detail with the Emoluments Clause that says a person holding a position of trust with the United States government should not receive a present or title nobility or an emolument, meaning profit or benefit, from a foreign government. Is that merely technical? technical in the sense that the President of the United States should be someone who was born in the United States, a natural born citizen. Oh, we heard a lot about that over the land. How many times did President Obama have to actually prove that he was born in Hawaii? Yeah. But we heard a lot about that. Why are those provisions in the Constitution that the President of the United States must be a natural born citizen, and that if you hold any position of trust with the United States government, you cannot receive presents, profits, and benefits from foreign governments? The founders were petrified of the risk that foreign governments would seek to use their money, the enormous concentration of wealth in the great European powers at the time, to take over our government, to do with their money that which they could not do through force of arms. The British could not win the Revolutionary War when we fought back with the help of the French. They could not control the colonies from over there with their redcoats, but could they control us with their money? Could they control our government with money? Because there's enormous concentration of wealth in Great Britain in the hands of the Crown and in the hands of corporations that were very much tied to either the Crown or members of Parliament, including the notorious East India Company, whose tea, I believe it was tossed into Boston Harbor in the Tea Party. I'm talking about the original Tea Party, not the people run around now talking about tea parties. And the enormous power and money in the East India Company, the British Crown, could this be used to bribe American politicians and office holders? And of course, you cannot prove a bribe. It's so hard to prove a quid pro quo. Just look at what happened recently in the trial of Senator Menendez of New Jersey. It's very, very difficult to actually prove quid pro quo. But the founders anticipated this problem. They wanted to say, we are going to have a prophylactic rule. We are not going to have any person holding a position of trust with the United States government who is accepting profits and benefits from deals with foreign governments. If it's a private company in Great Britain, okay, a really private company. But if it's government-owned or government-controlled, not happening. Because what's the point of throwing all the tea in the Boston Harbor and having an American Revolution, and then you have a president who's buying and selling tea with King George? That's not the idea. And Great Britain was not the only one. France, the time before the French Revolution, enormous concentration of power out there at Versailles in the hands of the king. And the French king, who didn't have a parliament to deal with, spent a lot of his time actually trying to bribe the British Parliament. So the King of Great Britain had a competitor there in his own parliament. The French king giving out various presents and benefits to members of Parliament. Edmund Burke, member of the MP, member of Parliament, got up on the floor of the House of Commons and gave many speeches about how corrupt this was. Where the founders over here didn't want any of it. There are other great powers at the time with enormous concentrations of wealth, Austria, Hungary. And then there was a fourth one, Russia, yeah. And they come back into the story. Russia for years, even back then, was seeking to corrupt various Polish and Lithuanian princes to reach into Eastern Europe and use the concentration of power and wealth in the hands of the czars. And this is a game the founders didn't want over here. So this is an obscure provision of the Constitution, perhaps because we don't teach it in law schools, but it's a very important one. It's about conflict of interest. And indeed, the founders were so worried about foreign governments getting control of the United States that somehow the British or somebody else might send someone over here to then become a powerful business person and buy favors and get himself elected president of the United States, that they put in that provision saying that no person who is not a natural born citizen could be the president of the United States. These provisions are there for a reason, particularly the Emoluments Clause about money and the corrupting power of money. And for me, of course, it's been quite troubling that President Trump, who continually berated President Obama over a non-existent Kenyan birth certificate with respect to one of those clauses of the Constitution, now stands in a position of quite clearly being a violation of the Emoluments Clause of the Constitution, receiving profits and benefits from dealings with foreign governments. Now, the profits and benefits from dealings with foreign governments that those of us who are working on this litigation have identified most clearly start with, of course, the dealings with the hotels. Start with, after the election, the hotel room rates go up at the Trump Hotel, and every foreign diplomat wants to stay there, and the various Middle Eastern countries that want to prove that they're on the good side want to hold a big, shindig in the ballroom and rent that out. We had that going on. But we also found that there are a number of foreign government-owned banks, Chinese government-owned banks that rent large amounts of space at the Trump Tower, and those are going to be renegotiated, those leases. So there's foreign government money there. And then the big question is there foreign government debt? We don't know. We don't know where the debt is. Now, all I know about the real estate business from my time in New York City when I was practicing real estate law, some of the time with securities law at Sullivan and Cromwell, is that there's a lot of debt in a real estate empire. There generally is. I don't blame Donald Trump necessarily for having 90% debt on the Taj Mahal casino. A lot of the real estate operators were that way. They weren't quite as leveraged as much as he was, but real estate is about debt. You get as much credit as you can from the banks, and the banks take the risk, and then you make money on the upside. If it doesn't work out, well, it doesn't work out. Well, after a number of those business failures in 1990, 1, 2, 3, Taj Mahal, some others, President Trump and the Trump organization had some difficulties obtaining credit in the United States. I don't know where the money comes from. You'd see some of that in the corporate tax returns for these closely held businesses owned by the president, but we don't get to see the tax returns. First president since President Nixon not to show his tax returns. So we don't get to see the tax returns. We don't know. But if he has turned to foreign governments, whoever those foreign governments might be, maybe it's the Queen of England, sort of doubt it. Maybe it's somebody else. I don't know. But that's a question of transparency. We don't have that information. And yet the Constitution makes it very clear that nobody, it's not just the president, nobody holding a position of power in the United States government can accept profits and benefits from dealings with foreign governments. So this is why at first I've asked Congress to look into this. Congress doesn't feel like doing this right now. They've got some other priorities. Over at the House Oversight Committee, I think they're finishing up with Hillary's email, and when they're done with that, well, there's Nunes memo, there's some other crises they got to deal with. So anyway, Congress doesn't really want to get into the emoluments question, even though it was important enough to the founders to put it in the Constitution. So that's one route, is to get Congress to focus on this. But if they're not going to focus on it, my group, Citizens for Responsibility and Ethics in Washington, CREW, versus the president in his official capacity, and that was filed in the Southern District of New York. And the problem, and you learn this in civil procedure, is that you not only have to have a winning case on the merits, you also have to have standing to succeed, or the court isn't going to hear your case on the merits. We do not have a system where just anybody can walk into the federal district court and say, well, I think President Trump has violated the Constitution, and I want to start a new case. If that were the law, we'd have a mile line long outside of the federal district courthouse, and be tying up traffic and so forth. So you need to have standing. And we believe we had a good standing argument for CREW, that we are an organization that's focused on conflicts of interest in government for 12, 13 years. This is directly central to our core mission, and is effective in the way we carry out our mission. At CREW, Judge Daniels of the Southern District of New York disagreed with us, dismissed the suit, and that is going to be appealed to the Second Circuit. That's case number 1 on emoluments. But there are 2 others making similar claims on the merits that have different standing arguments. The second is brought by members of Congress, because the Emoluments Clause says that you may not accept the profits and benefits from foreign governments, or the presence from foreign governments, without the consent of Congress. So actually, the founders understood there might be some situations where a public office holder should be able to receive a present from a foreign government, or maybe a profit or benefit or an emolument, but they should go to Congress first, or there should be a law that allows it. For example, Congress has passed the Foreign Gifts and Decorations Act, which allows someone to receive a gift, I believe it's up to $385, from a foreign government. I remember that well because I think the Saudi government, or someone affiliated with the Saudi government, tried to give one of President Bush's top national security advisors a Rolex watch. Said, well, that's a violation of the Emoluments Clause of the Constitution, unless it's a fake Rolex. Because $385, nah. And wait a minute, national security advisor or counterterrorism advisor, Rolex watch from the Saudi government, doesn't pass the smell test either. So return the watch, yeah, that's what we all thought the answer was. This is a situation where Congress can give consent to receipt of the present or the profit or benefit from dealing with a foreign government under the Constitution. Well, a number of members of the House and the Senate, led by Senator Richard Blumenthal of Connecticut, went to court, federal district court in the District of Columbia, and filed suit saying we were never consulted. Nobody asked us for consent. Now, none of the Republicans have been willing to join in this litigation yet. Now, maybe they might rethink that as November comes closer and closer. But it's a large number of Democrats filed that case. And so that's pending before the federal court down in the District of Columbia. And then there's a third case brought by the Attorney General of the state of Maryland and the Attorney General of the District of Columbia. Now, part of that is about competition with the hotel that is our ground for standing of local businesses. But the interesting argument that Maryland can make as well is that the Constitution is really a contractual relationship between the states and the federal government. Maryland was one of the first adopters of the Constitution. And as we learned in the Civil War, once you're in, you can't get out. We've been through that. So Maryland is stuck in this relationship with all the other states and this relationship with the three branches of the federal government. If one of those branches isn't playing by the rules, for example, the President of the United States is taking profits and benefits from dealings with foreign governments, well, shouldn't the state of Maryland have standing to go into federal district court and say, well, Your Honor, we want you to look at this. Now, if in these cases, any one of the three, the judge does decide there is standing, of course that might very well be appealed by the administration. The Justice Department is representing President Trump in this litigation because he is being sued in his official capacity. But if a judge decides there is standing and that standing decision sticks, then the judge would do what I've been urging the Congress to, is look at the facts, open the books, look at the tax returns, look at the data, find out where the money is, where's the money coming from, and then simply tell the president what he can have and what he can't have. And then, if he refuses, then you'd have a situation where there's a confrontation between the president and the judiciary. We'll see where that goes. But this brings up another critically important conflict of interest aspect of the Constitution. Is in the United States, we do seek to have an independent judiciary. Federal judges have life tenure for a reason, to insulate them from the political sphere, from what's going on in the other two branches of government. In order to get nominated for a federal judgeship, of course you play the political games with the White House and with the Senate. But once you're on the courts, there's a critically important independent role for a judge. We give the judge lifetime tenure. While it's permissible, arguably, I do not think it's particularly appealing to see a Supreme Court justice go give a speech at the Trump Hotel, as Justice Gorsuch recently did, when he might very well be hearing cases involving the Trump Hotel. We can debate about what judges should do, what they should not do with respect to their own independence. I have wished that the Supreme Court, and a number of Supreme Court justices, some very liberal and some very conservative, be somewhat more reticent with respect to various actions or statements they've made that might appear to compromise their independence. Always showing up at the Federalist Society dinner all the time, or the ACLU dinner, and I wonder how much of that should be going on for Supreme Court justices. But let's look at the other part, is that judges should not be subjected to attack from the political branches because of their decisions. Now, this isn't new in the United States. I was only 5 or 6 years old when the impeach Earl Warren movement was getting going. People wanted to get rid of the Chief Justice of the Supreme Court back in the 1960s. Not because he had done anything that violated judicial ethics rules, but because of his decisions in a threat to use the impeachment provision of the United States Constitution to remove a judge because of the ideological aspects of his decisions. That, of course, was pushed back. But I've been quite worried about the recent rhetoric from President Trump about so-called judges when a decision comes down against him in the Ninth Circuit on the travel ban case. That rhetoric, of course, he has the First Amendment right to say what he wants, I guess, about a judge, but this is not something you expect from the President of the United States. We respect the judiciary and the decisions of the judiciary. Even President Nixon, when he was told by the Supreme Court, you have to hand over the tapes, he handed over the tapes. We respect judicial decisions even if we disagree with them. We can appeal them, but we do not attack the judge. And of course, during the campaign, I was most offended when candidate Trump, now president, said that a judge was biased in a case against him because the judge was of Mexican-American heritage. That combines the attack on the judiciary and the independence of the judiciary with ethnic stereotypes. And that is exactly the type of rhetoric that, if allowed to get out of hand, can lead to disaster. Where repeated attacks in the late 20s, early 1930s in Germany on judges of Jewish heritage, saying that they were biased in cases involving Aryan Germans. And because bias should be removed. Within 2 to 3 months of the Nazis taking power in early 1933, the Jewish judges were removed. One of the first things they did to solidify political control over the judiciary. And then the next step being insisting that judges ought to be affiliated with a party or at least have a good relationship with a party. So the independent judiciary is critically important in the United States. Judges have a role in policing the boundaries of conflicts of interest in our government and upholding the Constitution. I've been through some constitutional provisions, but there's more, because we have conflicts of interest statutes in the United States. We have a financial conflict of interest statute. It's an interesting one. In 18 United States Code 2008, it is a crime for any United States government official in the executive branch to participate in a government matter that has a direct and predictable effect on that government official's financial interest. It is a crime. That statute applies to every single employee in the executive branch except for 2. The president and the vice president. The criminal conflict of interest statute does not apply to the president and the vice president. The Emoluments Clause of the Constitution does. That's about the foreign government money. But the conflicts of interest that don't involve foreign government money technically aren't a criminal offense for the president and vice president. They are for everybody working well, but not the president and the vice president. And it's true for the members of Congress as well. They are not subject to that statute either. One of the difficulties is that every time there is a suggestion that the president and the vice president should be subject to the same criminal conflict of interest provision that applies to everyone who works in the executive branch, is that defenders of the president and vice president say, well, it should apply to members of Congress too, then, shouldn't it? Well, that makes the bill dead on arrival. Because, of course, they don't make that rule. Now, this takes us back to the founding and the struggle that the founders of our country had with financial conflicts of interest. of members of the House and the Senate and the President and the Vice President. Because here, the founders had a blind eye to their own financial conflicts of interest. They were very cognizant of the conflicts of interest that could come from foreign government profits and benefits, hence the Emoluments Clause. But when it came to their own domestic financial conflicts of interest, they certainly didn't address the problem in the Constitution, and indeed, they exacerbated the problem. And here is the most poignant example. President Trump, when he took office, or before he took office, and he was criticized by a number of people, including myself, for holding on to the Trump Organization and his real estate holdings and all the rest of it. He said, well, gee, there's this exemption for the president and vice president. I didn't know about it, but that's a nice thing. And then he said, and I'm just like Washington and Jefferson. You know, Presidents Washington went home to Mount Vernon, Jefferson, his plantation down there at Monticello. They had businesses, thriving, successful businesses. So I'm like Washington and Jefferson. So I heard a little bit of that from Trump as a president-elect. And then I testified at the House Oversight Committee, one other committee. And one of them, the chairman of the committee, brought up that example. He said to me, well, how is what President Trump's doing any different than Washington and Jefferson? And they had the plantations. And are you saying, Mr. Painter, that Washington and Jefferson were unethical? And my answer, I got a good 4 or 5 minutes in on this one. He said, well, I think they were great presidents. I'm not one of these people who wants to eradicate all the wonderful things that Presidents Washington and Jefferson did for our country. But when it comes to those plantations, yeah, there were some unethical things going on there. Slave labor, yeah. And that was a serious financial conflict of interest for our first president, our third president, several other presidents, members of the Senate, members of the House. And Washington and Jefferson, many others, had vast plantations. They're very wealthy men, using large numbers of workers who are enslaved. And were they going to deal with the slavery question at the founding of our country, in the Constitution or in any other way? No. They didn't. So, was that unethical? Yes. Was that a financial conflict of interest? Absolutely. Financial conflicts of interest have consequences. And the most tragic decisions made at the founding of our country with respect to slavery, the inability to deal with that question until the Civil War, the legacy we've had after the Civil War, and continuing racism, and it has affected our country to this day. Those financial conflicts of interest of our first president, our third president, many powerful members of the House and Senate. Conflicts of interest have consequences. So we can say technically, yes, the members of the House and the Senate and the president and the vice president, they're exempt under the statute. So it's okay. Financial conflicts of interest are okay. And yet, we know full well that financial conflicts of interest for powerful people in our government, personal financial conflicts, can have tragic consequences for our country. And that's based on what actually happened there. So I let the chairman of the committee know I was really sick and tired of hearing about the Washington and Jefferson example. You want to tell me a story about George Washington and the cherry tree? Fine, but don't tell me about the plantation. And then another, maybe a more hypothetical example I bring up that fortunately did not happen. This has to do with President Trump's vast holdings all over the world and his investments in various countries around the world that are having some difficulties with respect to the democratic experiment, let's say. Is that in the 1930s, 1920s and 30s, quite a few very prominent business people in the United States decided that they could make very good investments in Germany as it recovered from World War I. Even the law firm I worked for a number of years, when it was run by John Foster Dulles, they had a number of clients in Germany, and American banks had good relations with companies over there. There's a lot of sunk money into Germany. And then the question is, what do we do about that in 1933 when you have a country which was a Republican form of government very quickly turned into a dictatorship. And a lot of American business people think about, how do I get my money out? Well, maybe I don't want my money out. Maybe if I put more in, and actually the National Socialist government was growing the economy for a while. We can make money off this. Why is it that relevant? What's going on over there? And that was the attitude for a lot of well-to-do business people who had money invested in Germany. And the situation got worse and worse and worse. My grandfather owned a small bond shop. There was just two of them buying and selling bonds in New York. He never made much money doing it, but he was having fun with it. He was on the other side. He thought we ought to go after Hitler. And when the war broke out in 1939, go in on the side of Great Britain. And so he was constantly trying to raise $50 here or there to run an ad in the New York Times. But the so-called America First movement, it was called, was adamantly against that. Now, the young people who started America First were young, idealistic pacifists at places like Yale and so forth. But a lot of the money that ended up financing the attacks on those who wanted to be more interventionists, like my grandfather, came from the big financial interests, including the Hearst Press, which would write a nasty story every now and then. This was a big debate throughout 1939, after the war broke out in September, 1940, 1941. And President Roosevelt had to make some decisions, and I think he did a lot of what he could to try and help Great Britain fighting against Germany. Debated whether he did enough, but he was always getting pushed back from Congress. Why is this relevant? Well, as I said, a lot of very well-to-do Americans had money invested over there. Franklin D. Roosevelt was a very well-to-do man from a prominent New York family. A little more old money than, I guess, President Trump, but whatever. Where would we have been if President Roosevelt had had a Roosevelt Tower in Berlin, another one in Frankfurt, $300 billion revolving line of credit with Deutsche Bank? That wouldn't have been a good situation. If he also, or if people high up in his administration had money sunk in over there as we were struggling to figure out what to do throughout that period before December of 1941, and even after that, whether after the Japanese attacked us, obviously Germany then declared war on us, but could that be worked out? What were the various options in front of our government in a very challenging situation? We do not want to have our president or high-ranking officials in our government with financial conflicts of interest. Now, with respect to all but the president and vice president, we have a criminal statute which would apply to these conflicts of interest. But the president and the vice president could have serious consequences if their financial holdings in a hot spot of the world, whether now it might be Turkey or the Philippines, a country, once again, democratic countries that appear to be, at least temporarily, sliding in the wrong direction. And I am disturbed that President Trump has a lot of investments. He's not in these types of countries. He's not investing heavily in Western Europe, Japan, Australia, the established democratic regimes that at least we think aren't gravitating toward dictatorships. He doesn't have a lot of money there. He has a lot of his money in other places, which is good for many Americans to be investing all over the world. We shouldn't just be investing in democracies. But if you're a government official, you're the president of the United States, and a crisis comes up, I'm very worried about that. So the financial conflict of interests are serious. And and lawyers, there's only so much a lawyer can do if the president says, well, the statute doesn't apply to me. And yet, one of the things government lawyers should be doing is explaining to the president the risks of certain other criminal statutes coming into play that do apply to him and apply to everybody working for him. For example, the bribery and gratuity statute. When the president's sons go touring the world selling condominiums or whatever types of deals they want to do, and then talk about United States government business at the same time, whether it's in India, or whether it's in the Philippines or in China or anywhere else, somebody somewhere may get the wrong idea. Somebody somewhere may get the false impression that if you give some financial benefit to the Trump family, you could receive some policy benefit from the United States. At least, I hope it's false. But that won't prevent someone from having that impression and making such an offer. And it's certainly exacerbated when the president's sons are talking about government policy on these tours. They used to be bringing the Secret Service in tow with them to make sure everyone understood their sort of semi-official role. It doesn't help when the Kushner family, when they are going to China to try and attract investments under our EB-5 program for the visa you get if you invest $500,000 in the United States, when they put a big picture of Jared up there working for President Trump. Yes, hint, hint, you might get the visa a little more quickly if you invest with us instead of someone else. Now, I know that's not Jared Kushner, that's his sister. And then they took it down, and they apologized, but then they did it again. Well, this is a serious concern with respect to the mingling of financial interest and government power. But I will say that this has been the norm throughout much of human history. Because you look at the old British Empire, that's the way it was. Money, having an enormous influence on Parliament, and in relationship between big companies like the East India Company, before that the South Sea Company, and the members of Parliament. That's what mercantilism was about. That there was a close relationship between the people who ran the big companies and the government and their families. China, today. The New York Times a number of years ago did a detailed study of the very successful businesses in China and the links with members of the Communist Party and their families. The family connection. Very detailed study. Very well done. The New York Times website was down in China for about 2 weeks after that. And indeed with this going on in Russia. So this combination of government and business, this conflation of government interests and private interests, is a serious risk, at least to the way we envision government in the United States being separate from the business interests, or the way it should be. Are we going to gravitate toward the type of system they have in China and in Russia, in the old British Empire? Or are we going to be able to the extent we can, keep government interests, the financial interests of government officials and their own family businesses separate? And this is the challenge that remains ahead for us. These are all conflicts of interest that government lawyers struggle with. I don't know if I have any minute to take a question or two.
Sure.
And I'd just like to take a question or two, maybe get a discussion going. We have some time.
We do need to end in about 5 minutes.
5 minutes. Well, jump in.
Thanks for this discussion. And I, just based on what you last said, we should be worried about the conflation of public and private interests. But isn't it sometimes helpful if you have someone come from the private sector into the public sector and he's worried, and I understand maybe the separation should be between the person and his own assets, his or her own assets, but what about his or her friends, right? So if we think of ethical decisions, it's not just perhaps concern over my assets, but what if I come from Goldman Sachs and I work in the Treasury Department and I want to help all my friends? Isn't that a good thing?
Yeah, Goldman Sachs, yeah, the government, we nicknamed it the government Sachs. The revolving door. I think it's believed is a good thing in the United States. There are other models. France and some other countries have a stricter model. We either go to government service or you go into business, and more rarely do you switch between the two. The problem there is you can have a government that doesn't really understand the business sector and how it operates. So we have brought in people from Wall Street to become Treasury secretaries. We've had 2 from Goldman Sachs, one under Clinton, Bob Rubin, and Henry Paulson under President Bush. This has been quite common. Obviously, there are pros and cons of it. And the con is that you have the financial ties. You make them sell the stock. And I told Hank Paulson he had to sell $600 million worth of Goldman Sachs stock. I felt very bad for $600 million. They have some rules with respect to their interaction with their prior employer. When they leave the government, they're representing back to the government. So we regulate the revolving door, but it's a constant balancing test. But I think it's a great thing when people come from business into government on the whole. But they usually sell their assets. And so how are we penalizing Donald Trump by asking him to sell the assets when the Treasury Secretary is required by law to sell the assets? And then he says, well, I've got all these real estate holdings and they're hard to get rid of. Well, then you read a book called The Art of the Deal, and it'll tell you how to get rid of them. So we have a revolving door, but we have rules to try to make it work, to alleviate the conflicts of interest. One more.
And what about all these judges that are being appointed by Trump, and where do they come into play with lawsuits like the one year ago? Richard, could you repeat?
The judges appointed by President Trump and where they come into play on these lawsuits. Judges who are appointed by President generally can decide cases in which the President and his administration are a party. Simply because they were appointed by the President would not be grounds for refusal. I do feel, however, that when a President appoints a justice, it is important for the justice to distance himself from the President's administration. In the old days, the justices of the court, they quit their club memberships and so forth. You just didn't want to, you wanted to be independent. That's why I'm concerned when Justice Gorsuch goes and gives a speech at the Trump Hotel on something. I don't care what it's on. Because the Trump Hotel is sort of ground zero for lobbying and all that stuff. So I think that judges appointed by this president, a lot of people are very concerned about the nature of these judges. I don't think that, in terms of judicial appointments, I think most of them haven't been that different than what you would have gotten out of another Republican president with a Republican House and Senate. Some of them, whatever. I do feel that if they want to encourage respect for the judiciary, they really ought to not be showing up certainly at the Trump Hotel, hanging around with the Trump administration, or coming back to the Federalist Society for approval after they've only been there a year on the job. I just think that there's an image issue there. Independence of the judiciary, it needs to be encouraged here. The judiciary is under attack, and I think the judges have their role too. And I've seen some of the liberal judges do this too. Making political comments or showing up all the time at liberal organizations. And I just think that right now, judges should focus on being judges and let the political system work the way it does.
Thank you so much. Sorry, we have to cut this short because he would have liked to encourage a conversation. I'm sure we could stay and listen for another hour, but we have to let him go. So thank you so much for joining us. We really appreciate it.